disputes, conflicts of interest, and attorney-client privilege and confidentiality issues. I am chair of the Bar Association of San Francisco's Legal Ethics Committee and also a contributing editor to the professional responsibility section of the Rudder Guide on Employment Litigation. And I'm going to turn it back over to Diana now to start our presentation.
Thank you very much. Now we're going to both turn off our video so that you'll just see the PowerPoint. And all right, so privacy best practices for lawyers. You all know that's why you're here. Let me just start by talking briefly about what privacy law is. And, you know, privacy law is really a term that has to do with a number of different kinds of laws. It's a very multidisciplinary area of the law. And it's basically laws that deal with the regulation, storage, and use of personal information about individuals. So there is a lot of data out there that obviously doesn't have anything to do with people, and that is not encompassed in privacy law. But short of that, any data that has to do with a person is going to be subsumed under some kind of privacy law regulation generally. And generally, privacy laws can be classified depending on the kind of data that they protect or regulate. There's sensitive personal information. And in the US, that's things like social security numbers. But in other places, it's different. So in the EU, for example, it's race or membership in a trade union, things like that that have been used to persecute people historically. So it does differ depending on the context, but basically more sensitive personal information is more closely protected. Then there's just general personal information wherein someone's identified, and it can be something like their name, maybe a first, middle, and last name that's unique enough that it's pretty obvious who you're referring to, or it could be a name, a more common name in conjunction with other factors. So again, you can identify the people that that you're talking about. And then there's, of course, non-personal information that might be regulated. You know, some privacy laws that deal with non-personal information are more like things, you know, in the communication area where you're talking about reaching into somebody's space. It's not so much the fact that you're using somebody's contact information, because although you are, but the regulations really focus around how you're outreaching to people. And, you know, in the US, we do things a little differently than in other countries. We have really sectoral privacy laws. So I tried to basically follow that idea and give you a sense of the ways that privacy laws can be broken down. And one of those ways is to look at it as communication privacy is one sector, and that would be things like the Telephone Consumer Protection Act or the CAN-SPAM Act, and they regulate email and phone calls. And then financial privacy laws, which are the Fair Credit Reporting Act or the Gramm-Leach-Bliley Act, things that regulate what you do with financial information or personal information that's non-financial but held by a financial institution. Then there's health privacy laws, and obviously the one most people know is HIPAA. HIPAA is the federal law that regulates what privacy which information has to be kept private and confidential, and when you disclose it and when you don't. And in California, we have a similar law called the CMIA, which is basically like a California HIPAA, but not quite as stringent as HIPAA. And then online privacy laws is another area, and I put COPPA under that. That's the Children's Online Privacy Protection Act, which says, for example, that you can't take information over the internet from minors without parental permission. And CalOPPA, which is the California Online Privacy Protection Act. And that's the law that says that if you have a consumer-facing website in California, you must have a privacy policy. And that law is often disobeyed, but it is out there nevertheless, and it's a very important law for people to follow, particularly larger commercial operations. So why is privacy law so hot right now? Well, I think there's a couple of major things to think about here. So first of all, obviously with the internet, the stakes have gotten a lot higher. So you have, millions of people sending off private and sensitive information. And if that information is intercepted or mishandled, the consequences can be really dire. Last year, or I think this is about 2 years ago now, Target's CFO said that the breach that they had affected about 40 million customers in just the payment data. But it kind of broadly looking at phone numbers and addresses, as many as 70 million people were affected by that breach. So the consequences are really quite extreme when data is mishandled and it's and it's done so over the internet. And so you see more of an impetus to regulate how that data is handled. And as the internet becomes increasingly popular, there are a lot more communications that occur, and that means that consumers have new ways they want to be contacted and new ways they want to not be contacted. So, there's new annoyances. There's, the do not call list that came up. There's the Can Spam Act around email. There's junk faxes. So as we have all these different ways of reaching out to one another, there also becomes a need to regulate some of those ways so that people still have somewhat of a private life. And lastly, there is an area of privacy called big data. And big data is basically huge amounts of information that are in and of themselves may not mean anything, but when you analyze the data and you extract different variables from it, they come to have meaning. So, for example, there was an incident that happened a few years ago. Again, Target was involved in it, and Target was looking at thousands and thousands of data points, and it found that women in their first trimester of pregnancy had a number of things in common. One of the things they had in common was they all purchased voluminous amounts of lotion, body lotion and hand lotion. And I'm not sure why that is. Dry skin maybe, I'm not sure, but that was something they noticed. So that in conjunction with some other data points, what they started doing was they sent to people coupons for diapers and formula and things like that. Well, a father came into Target one day and said to the manager, was absolutely outraged and said, you've been sending my daughter coupons for Pampers and formula, and what is the idea? She's 16 years old. This is absolutely horrible. And they were profusely apologetic. And the manager's manager called to apologize the next week. And the father said, I actually owe you an apology. It turns out my daughter is pregnant and I just didn't know. And so, this is a pretty stark example, but it does give you a sense of how this data, which may mean nothing in and of itself, and it's not linked to anyone in particular, but when you extract variable points from it, it allows the people that have a hold that are, have this data in their possession to have a kind of a weird kind of power that doesn't feel very good if we don't have any regulations around it. So how do we practice good privacy? Well, basically what we did is we looked at good privacy practices really all over the globe and came up with fair information privacy principles. And these are practices that, again, are globally accepted as good privacy. And there's 5 components to it. There's 1, notice or awareness. So that's letting people know you're collecting their data or letting people know you have their data. Choice or consent, and that's asking someone before you collect their data. And access participation, that's allowing people to see the data that you have on them and to amend that data if possible. That's the requirement that's in place in a lot of laws, for example, HIPAA, you can edit your personal health record in certain situations, so you are allowed to access it, see it, and make a request for an amendment to it. Integrity or security basically says that, make sure the data you're holding is accurate, cross-reference it against multiple sources if you're not getting it from the individual, him or herself, and keep it protected. That's why, for example, in HIPAA, there's all these rules about the kind of technological and policy safeguards you need to have in place in order to protect personal health information. And enforcement and redress, and that basically says that in any good privacy system, there has to be a mechanism by which a consumer can make a complaint about a violation of her privacy, and there's a remedy. And that's why you see, a wide amount of regulation depending on what the privacy issue is. So here's some general issue spotting to think about, and this is issue spotting that's good for you to talk to your clients about, and it's also good for you to think about as a business yourself. So how do you collect, use, and share information? Do you really need to be collecting the information that you have, and what are you doing with it once you have it? Where is it stored? Is it stored securely? And we're going to talk about this a little more later in the presentation. Particularly, you want to think about, are you possibly taking any data from the EU, even if you're using some kind of a service which maybe has a cloud that is hosted in the EU, and then you're getting data from the EU, and then you're uploading it here in the United States? That's a transfer of data according to EU law, and there are very, very, very discriminating standards in accessing that data now. So you need to be really careful with it. You want to think about how your information is collected and how it's shared. And you really want to follow a principle of data minimization. So really only collecting data that you absolutely need, and not asking for a social if you don't need it, not asking for race or ethnicity if you don't need to know that. So really thinking about where is this data going, and do I absolutely need it? Is there a more protective way to deal with the data? Can you process it in some way that very few people get access to it? And thinking about those people that will get access to the data, how do you know that they'll keep the data safe? Sometimes that means putting in place an agreement with your vendors, depending on what the data is. And one thing I'm a big advocate for is a privacy policy. Again, this is now a requirement under CalOPA, and so you do need to have a privacy policy on an external facing website. But I think besides following just the law, it has a really great business development, or not, it's a very savvy thing to do customer-wise, because it lets your clients know, or your customers know, that you really do think about their privacy, that you're paying attention to it, and gives them some reassurance as to what policy, what practices you follow. One caveat, though, is not to have a privacy policy that you really don't follow. So it's better not to have a privacy policy than to have a policy that you don't truly follow, because that can get you in trouble down the line. So why are privacy practices so important? Well, most privacy laws apply to law firms and attorneys just like any other kind of business. So, for example, the protections around importing data from the EU, those apply to any business in the US, or really any individual in the US, depending on what kind of data you're transferring. And all of the laws that apply, to protecting privacy really apply across the board. They generally don't discriminate based on the kind of entity at hand. What are the risks if you don't comply? Well, there are a lot of them. So you could be subject to an enforcement action by a government agency. The FTC is the biggest agency that enforces privacy, although there's quite a few others. For example, the Office of Civil Rights is the agency that enforces HIPAA, and the FCC is the agency that enforces the TCPA. But the FTC does, I think it's fair to say, by far the most enforcement work. And just a number of decisions that have come out recently are the ones that I have here: Dave & Buster's, BJ's Wholesale Club, Guest.com. These were cases where different entities either just didn't have good privacy practices, or had a privacy policy that said one thing when they truly did another, or they warranted something in their software and their software didn't do what it said it would do, or you downloaded software, and in downloading software you gave the company access to something on your computer. Those are the kinds of things that led to FTC enforcement actions. There's also going to be contractual liability depending on what you warrant in your contracts regarding privacy. There can be civil and criminal penalties, particularly in the EU. But I believe HIPAA carries with it criminal penalties in some circumstances. And I think a big one is reputational harm. Sarah's going to talk more about the very specific sort of reputational / viability of later practice harm that can come to law firms. But, it's just good to think about the fact that, again, good privacy is good business, and it reflects well on your business. It looks professional, and not following good privacy practices doesn't. So I'm going to turn this over to Sarah now, and Sarah is going to talk about some of the unique challenges with privacy compliance that come to law firms.
Okay, and as Diana mentioned, law firms are not immune. Like other businesses, law firms are increasingly using cloud-based services to collect and store client confidential information, and they're subject to the same privacy laws that Diana went over. In fact, many recent reports, including a report from the FBI, have warned that law firms are the weakest link when it comes to digital security. And unfortunately, at many law firms, their practices with respect to privacy of their confidential client information remains below the standards for other industries. When typically I've presented on this topic in the past to a variety of bar association groups, and when it's a live presentation, I survey the audience just to see how many lawyers work at firms where they have either privacy policies, social media policies, or bring your own device, what's referred to as BYOD policies. And I'm generally surprised at the small number of hands that are raised. It's usually only about 5, at most 10% of the audience whose law firms have these policies in place. Another recent report from the Wall Street Journal has reported that there's been a 40% increase in publicly disclosed breaches since 2011. And this includes at least 80 of the 100 biggest firms in the country that have been hacked since 2011. And since at least 2009, the FBI and other governmental agencies have been warning managing partners at some of the big firms that their computer files are targets for cyber spies and thieves in China, Russia, and other countries, including in the US, where they're looking for valuable information about potential corporate mergers or other transactions. So currently, a lot of clients, especially banks, are conducting audits and requesting law firms to stop putting files on portable thumb drives or emailing them to non-secure iPads, and also not to work on computers linked to shared networks in China and Russia where hacking is more prevalent. So,
Sarah?
Yes.
I'm just going to interrupt here for those that are entering late. Please feel free to, if you have questions, you can just put those in chat, and I'll monitor those for Sarah. Thanks.
Great. And also, so lawyers have to comply, in addition to the privacy requirements, but also with the rules of professional conduct, which have not always kept pace with the evolving technologies that attorneys are using in their practices. It's reasonable, as I mentioned, to expect that law firms will be the targets of attacks by either foreign governments or hackers, because they are repositories for sensitive confidential information on corporate deals, on patents, trade secrets, and other business strategies. Especially if you practice in the employment law field, or if you work in mergers and acquisitions or the healthcare industry, you are collecting a lot of sensitive client data. An issue also comes as law firms are storing this confidential information, particularly as more employees are working remotely. This can lead to increased risks, which is why a BYOD policy is so important. An example is if an employee has a stolen laptop with an unencrypted hard drive, that could create serious risks to confidential client information. If you have a policy in place, and as more and more data is now being hosted on the cloud, the firm may be able to mitigate the loss by wiping the laptop externally. Also recently, there have been a lot of cyber attacks and attorneys falling for email hoaxes in which the hackers are trying to gain access to confidential information by posing as someone else, even maybe someone internal to the law firm itself. So cloud computing can offer a lot of benefits and efficiencies and decreased costs, but law firms, like other businesses, are relying on it for firm sharing, file sharing, and billing support or e-discovery. But at the outset, you should always consider the sensitivity of the data you're collecting from your clients and the risk tolerance of your particular client. Excuse me?
Sorry, just want to interrupt you with a question here. In light of what you've just said, does something like Dropbox meet the requirements for protecting information?
Yes, and that's an interesting question, and I've seen a similar question posed at some prior seminars. And I think, as far as I'm aware, the rules obviously don't directly address this, or some of the more recent Bar Association ethics opinions that have been addressing some of the issues with new technologies. And I know that many, even clients, are using Dropbox to transmit data or to store it. And I think it really depends on the type of information you're using Dropbox. If it's highly sensitive information, I think it'd be worth getting your clients informed consent if you intend to use Dropbox before you do that with highly sensitive information. But as a general matter, I don't think that necessarily you'd have to evaluate. I personally don't know that I would want to look at the security issues with Dropbox and consult with maybe an IT person to see if it creates any greater security risks than other forms of technology that are commonly used and accepted.
Sir, I can add a little bit here too. Things like Dropbox and cloud storage services like Box have, usually what they do is they have a variety of levels, and you can get more secure levels. Like Box is the only one I know of that has a HIPAA compliant security levels. So for example, if you were a law firm and you were self-insured, you might have to, you'd have to probably comply with HIPAA. So in that case, you'd have kind of special obligations in addition to those Sarah was just talking about, and you'd probably want to use something like Box, and you'd use their most secure level, which would be HIPAA compliant. So it is going to depend a little bit on which service you're using and which kind of level of service you're using. And I do think an IT person can probably answer that best. The one thing I don't really know the answer to is it preferable to put things, say, in the cloud, or is it preferable to leave them on your computer with maybe a secured hard drive? There's pros and cons to both. But it is worth thinking, taking a careful look at whatever you're doing and maybe having an IT professional weigh in.
Yeah. And as Diana mentioned, actually, the last question she posed, probably about 10 years ago, a lot of the bar associations were addressing the issue of, from a legal ethics perspective, whether it's possible for attorneys to use cloud-based services and still comply with their ethical obligations. And with the increasing use of cloud services now? I think the answer is overwhelmingly yes, including ethics opinions issued in California. But the use of those cloud computing services by lawyers has to comply with your ethical obligations, which can be more challenging in a cloud-based format. In addition to storage, attorneys also have to think about data retention and destruction. And how long do you have to keep the confidential client information and files that you're storing? And in doing so, you have to consider a variety of factors, such as the statute of limitations, requirements under particular laws, and also look to your engagement agreement. See if you have a provision about how long you will retain the client files. Generally, many firms might have a provision where you retain them for 5 years. There's not necessarily a set standard under the rules of professional conduct. There is a rule that I'll get to later that deals with record keeping and with respect to the client trust fund accounts. And as a rule of thumb, sometimes law firms do the 5-year period. But even if you do have a provision in your engagement agreement, before obviously destroying any confidential client information, you have to, you really should notify your client about that and try to get the client's consent or send the information directly to the client. And also in destroying the confidential information, you have to make sure that you securely destroy it so that you don't permit access to some of that confidential information. And several bar associations have addressed contracting with outside vendors to dispose of confidential information. And there's information on the slide about an Oregon ethics opinion, which basically says that you may contract with an outside vendor provided that you instruct the company about your duties under the rules of professional conduct and get the vendor's agreement to treat all materials appropriately. So I've listed on this slide the primary rules of professional conduct, both the ABA model rules and the California rules of professional conduct that are implicated by lawyers' increasing use of new technologies to transmit, store client data. So I've listed both sets of rules. In California, keep in mind that unlike every other state, they still have their own set of rules that is not directly based or parallel to the ABA model rules, so they'll share some of the same provisions. Right now, the California rules of professional conduct are being drafted and revised, and the estimated date for completion is March 31st, 2017. In California, the rules of professional conduct form a basis for discipline as opposed to a common law standard of care, but California lawyers should also look to ethics opinions. They could also look to the ABA model rules for guidance and case law, particularly since the rules don't always keep pace with the evolving technologies. Unlike the California rules, the ABA model rules have been amended more recently to reflect the lawyer's use of new technologies. For example, for the duty of competence, a comment to this rule now says that this duty includes keeping abreast of the benefits and risks associated with relevant technology. And also new comments were added to the duty of supervision under the model rule to make clear that when outsourcing legal work, lawyers have a duty to make sure that the vendor's work is compatible with the lawyer's professional obligations, and this would include using cloud providers. In California, there's not a separate duty of supervision, but that duty is contained within the duty of competence. And there has been also a recent California ethics opinion that has addressed that and made clear that an attorney must take efforts to preserve confidential information when supervising vendors, and that this is governed by their duty of competence. One of the primary duties that I wanted to emphasize here is the duty of confidentiality. And under California law, that's not just a rule of professional conduct. It's contained in the State Bar Act. It's the duty of an attorney to maintain inviolate the confidence and at every peril to herself to preserve the client's secrets. This standard in California is much more stringent than under the model rules, and there are fewer exceptions to the duty of confidentiality. It's broader than the attorney-client privilege, and it'll cover information that's not necessarily privileged. And it is so broad that it even applies to information that is otherwise publicly available if the disclosure might be detrimental or embarrassing to the client. And several ethics opinions, since the rules have not been revised recently, have attempted to issue opinions giving some more guidance to attorneys. And some of the recent California State Bar ethics opinions make clear that lawyers have to take reasonable measures to safeguard this information, and in some instances might need to consult with someone who possesses the requisite technical knowledge. And keep in mind that mastery is not required, but you have to have at least a basic understanding of the electronic protections afforded by the technology that's used in your practice. As I mentioned, the model rules have been amended more recently, including the duty of confidentiality, which now makes clear that lawyers have to undertake reasonable efforts to prevent the inadvertent or unauthorized disclosure of confidential. And a revised comment also discusses the duty to safeguard confidential. An interesting application of the duty of confidentiality comes with lawyers and clients' use of social media. As a practical matter, you should be careful not to discuss confidential client information on public social media forums. For example, I'm a member of several different listservs for some groups, and attorneys frequently pose maybe hypothetical questions to obtain some feedback on cases they're handling and may not realize that the opposing counsel is also on that listserv. So you have to be careful before really posing any question, even if you're trying to mask some of the confidential information on any sort of social media forum, such as a listserv or blog. In addition to being careful with your own practices and using social media, you should also advise your clients at the outset of the presentation about their use of social media. They should be informed that they have no reasonable expectation of privacy, and this includes even with the private sections of their sites, such as Facebook. Many courts now, in deciding motions to compel, have turned on whether the party might have evidence from some publicly available portion of a party's social media profile to show the relevancy of social media postings on the private sections. And in some instances, they are compelling discovery that includes those private sections. It is permissible, according to several recent ethics opinions, to advise your counsel to change their profile settings to private. Of course, you obviously cannot advise your client to destroy any relevant evidence, but just changing the profile setting is permissible. And also, your advice to your client might include issues of credibility. A recent case that was in the news involved a widower husband who brought a wrongful death action, and he was on his Facebook account, the public portion, and posting pictures with scantily clad women and t-shirts saying "Hot Mama." So that obviously impaired his credibility in that case.
Sarah, question for you. When it talks about the duty to let your client know that what they put on social media is discoverable, is that contemplating litigation, or is that in general? I
think mainly if you're contemplating litigation. I think if you're handling any sort of litigation matter, or even a dispute that may turn into litigation, you should really advise your client at the outset and follow up as well during the representation.
Thank you.
And then the other duty that I wanted to address is the attorney's duty of communication. And that's the duty to keep the client reasonably informed about significant developments and to promptly respond to reasonable requests for information. And a revised comment to the model rule makes clear that with the changes in communication technology, it really enhances your duty to promptly respond to clients' requests for information. You also have to take into account client instructions about how they want to communicate with you. And in some instances, it might be necessary to have a face-to-face meeting to make sure the client is really understanding the legal advice you're providing. Another issue that's involved is, what if there is a breach of confidential client information that's stored on maybe by a cloud provider? You have not only internal requirements to make sure you notify everyone and report the lost or stolen device, but you also have to promptly notify your client of any breach involving their information. So what steps are required? As I mentioned, the California State Bar has issued an ethics opinion trying to give more guidance to attorneys about some reasonable steps. And they've listed a variety of factors that you should consider that are on this slide. The first is the level of security offered by a particular device. Now, that includes, as I mentioned before, how that device differs from other commonly used media, such as email, which present similar risks of unauthorized review. And also whether reasonable security measures may be taken to increase the level of security, such as passwords, encryption, and limitations on who is permitted to monitor use and on what grounds. The second factor the State Bar references is the legal consequences for unauthorized use or access. For instance, the fact that a third party might be subject to criminal charges or civil claims for accessing the information favors an expectation of privacy with respect to the use of that technology. The third factor, and an important factor, is the sensitivity of the information. If it's highly sensitive, you really should consider obtaining your client's informed consent before using particular devices. And the fourth factor is the impact to the client of inadvertent disclosure. That might include a waiver of the attorney-client privilege. You should also consider the urgency of the situation. In some situations, it might be necessary to use a particular technology that you might not otherwise use to address an urgent client need. And if there are no reasonable alternatives available, then it might be permissible under limited circumstances. And finally, it's client directions and circumstances. So if you're aware that your client, that others might have access to your client's electronic devices or account, you should warn your client at the outset not to communicate confidential information. This comes into play frequently in employment law matters. If you're representing an employee, you should warn them not to communicate confidential information from the company's email account. This includes not just email accounts, though, but also any sort of mobile device, such as a mobile phone that might be subsidized by the company and subject to monitoring. A couple of recent ethics opinions, including in California and the ABA, have issued opinions saying that this is now part of your duty of competence to provide this warning. And finally, just keep in mind that it's not only external hacking concerns, but also disgruntled employees and ignorance.
Sarah, can you go back one slide for a second?
Sure.
Is there certain technology that's considered, are there, and I don't know how explicit the opinions are, do they call out certain technology that's generally considered high risk or not acceptable, and then other that is considered low risk or more acceptable?
They don't go into that much detail, and it's usually ethics opinions err on providing that level of detail, but at least one of the ethics opinions, the factual situation was presented was an attorney who went to the local Starbucks and connected to the public Wi-Fi system there. And the issue is whether that was permissible. And the answer is really, well, it depends. Did the attorney have a firewall? Was his hard drive encrypted? What kind of work was the attorney doing? If it's just Westlaw research, well, that might be okay. But if you're working on a sensitive merger, then you wouldn't want to necessarily connect to the public Wi-Fi without ensuring that there are any security measures in place. So it really, it does depend on the facts of each case. And as I mentioned, of course, if you're traveling, connecting to a public Wi-Fi in certain countries would be riskier than in others. So.
Thank you. And Sarah, I just want to say, because I'm getting a couple private comments, that you can feel free to just put a question into chat, and I will repeat again at the end how you do this, but we will make this PowerPoint available to everybody. Great.
So I wanted to go over another application of both the duty of confidentiality. This has come up frequently in my practice in advising lawyers and law firms on what can they do in response to a negative online review by a former client. And in fact, as Vice Chair of the Bar Association of San Francisco, their ethics committee, a couple of years ago, I worked on an ethics opinion that we published addressing this issue because we had many members raise this issue with us. And the Los Angeles County Bar Association also issued an ethics opinion. So you can go to these opinions for more information. But the basic response is, yes, you may respond to the negative online review, but you have to be very careful not to reveal any confidential client information in doing so. And remember, as I mentioned, that even publicly available information might be considered a confidence or a secret if it would be detrimental to the client, especially if the client has an ongoing legal matter. So for example, an attorney might want to post, well, these are just lies and the client is refusing to pay my bill and that's why they're making up these false complaints. That might be detrimental to the client where they're engaged in ongoing settlement negotiations, and you shouldn't disclose anything to that nature. In fact, recently attorneys have been disciplined by state bars for e-shaming their former clients, including in Colorado was the most recent incident in which the attorney was suspended for 18 months for revealing highly sensitive information in response to a client's online complaint. So a few practical tips here are to avoid the gut reaction to just respond right away. And if you do want to respond, consider saying something just to the fact that you disagree with the statements in the review, but your ethical obligations prohibit you from responding more directly to the statements. Also, you might want to consider practically whether the response will just draw more attention to the review. So I'll leave, you could refer to the ethics opinions for more information because they go into a lot of detail about the evidence code provision that permits you to reveal confidential information, but that really is limited mainly to malpractice and fee dispute filed actions. It also goes into whether it's considered a waiver of the privilege if an attorney, if former client posts information. And I think generally the answer is no. I want to spend a little bit of time on cloud computing as more and more lawyers are using that with their practices. And it looks like I might have just had a question. So I'm going to see, Diana, did you see a question on your end? I'm having trouble accessing it.
I saw that someone was maybe raising their hand, but then it, oh.
Okay. All right. So I'll go on for now, but feel free to use the chat to raise a question.
Oh, wait, hold on a second. Okay, Lisa, do you want to ask a question?
Yes, thank you. I'm not sure how to use chat. I tried to send you something, Diana, but I've heard that email in particular is a very risky way to transmit confidential information. And I wondered if you knew of any internet service that was basically met the state-of-the-art requirements under the to safeguard confidential attorney-client communications and documents that are transmitted over the internet.
Lisa, it was really hard to hear you. I think, were you asking, you're saying, I think that email is a risky way to communicate, and is there technology that puts it more in the realm of acceptable? Was that the gist of your question?
I was speaking in particular about Gmail being risky, and is there a better internet service that you think would satisfy the duty of care?
Yeah, Sarah, do you want me to weigh in on that, or?
Yeah, if you want to weigh in on that.
Sure. Yeah, I mean, I think it's a really important question, and I can't tell you that there's a standard answer. I don't think there is. I mean, I think as Sarah's pointing out, a lot of these things, they don't have a black and white answer. They're saying use reasonableness. But, you know, one thing I do recommend, I mean, they have these secured email server, you know, like email interfaces. Like if you ever email your doctor's office, they where you have to log in. Someone's asking me what the question is. So, the question essentially was that, Gmail, for example, in particular is problematic. That can be intercepted, and email in general can be intercepted. And, does that meet the duty of care, or would you have to do more? And I was saying that my understanding is there is no kind of opinion that says here is the bright line rule, but that yes, I think it's a very valid point that email is sensitive. And actually, I was going to say this at the end of the presentation, but one of the best practices that I recommend is if you do really like to use email and you're sending information back and forth on it, private, and sensitive personal information, you might consider getting a secured email interface like the kinds you see a lot of people use to correspond with their doctor's offices, where you sign in with a password and then they sign in to send it to you. So it's like a dual password. I forget what you call that, but basically where a dual factor authentication. That is one way to think about it. That being said, I think that a lot of people do use email. The other thing, but I don't think it's a great idea. I think the other thing that I do sometimes with clients, if I have some documents or something that's really sensitive, I put them into, Dropbox, and I send them the link, and there at least it's password protected. So, I think it's going to depend on what kind of information. It's going to depend on your client. I think it's a worthwhile conversation to have with your client. Sarah, do you want to add anything to that?
I think you've really addressed the main points. I can't think of anything further to add to that. The only other point is obviously too with attachments too, that many services, including Outlook, I know offer the scrubbing feature, and that might come into play if you're exchanging documents with opposing counsel, where you might not want to reveal any metadata.
And then Lisa wrote that she's heard Gmail is definitely not secure, but is there a state-of-the-art email service for transmitting confidential attorney-client communications and documents? I don't think there is anything that's necessary that in and of itself that you would just buy that was like a free service. That you would just use that's a free service. I'm just wondering if anybody else knows of kind of a more, without purchasing, say, an additional encrypted interface or something, if somebody else knows. And Lauren, would you know?
I do not know, but I could find out.
Okay. So I'm going to just move on because I think we just have a little bit of time quickly, and I want to allow just at least a few minutes at the end for questions, additional questions. So I wanted to just go over, as I and because this does create some increased risks, but although it's permissible to use, when you're using it, you have to kind of stay current with any technological advances for using a cloud storage type system. And the New York State Bar Association has issued a set of comprehensive guidelines, and I've listed those in the final slides. You can look at those for more guidance. They might even go into more information in response to the previous question about particular email services. I don't, but they do go into more of a practical guidance as opposed to many of the rules or ethics opinions that don't go into as much detail. But one of their suggestions is to include a provision in your engagement agreement if you intend to use cloud storage. I don't think that's necessarily required by the rules, but it is a good practice, and it's also recommended, as I mentioned, if you are dealing with particularly sensitive information, to discuss that and get your client's consent. Also, make sure that you're vetting the providers, looking at their experience in both your client's industry and the legal industry. More and more cloud providers are now starting to target the legal industry and are generally familiar with the obligations that attorneys have to safeguard confidential information. Consider also whether the vendor has backup provisions for the information it's going to handle and store, And what about measures in place to prevent a lapse in services? If there's an earthquake, or what happens if the vendor goes out of business, or you decide to close your account, you need to make sure that you have a way to ensure the prompt return of your client's data. Also, is the cloud provider able to receive and comply with the litigation hold notice? Also, check your professional liability policy. Sometimes they're now covering data breaches, and if not, you could assess whether separate coverage might be appropriate depending on the facts. In addition to doing your own due diligence, some contract negotiation pointers are to really look at the service level agreement to make sure that the service provider is adequately protecting the confidential information. Look out for indemnity provisions that they might try to put in there, requiring the lawyer to indemnify the vendor in the event of a breach. Also, consider the extent to which you'll be able to supervise the vendor. Remember, you have this duty of supervision. And given the use of cloud services by many businesses, including law firms, it's really unrealistic now for the cloud service providers to permit outside auditing necessarily, but many do their internal auditing on a regular basis and will write a report if requested. And so if the vendor is not doing those audits or providing you copies of the report, that should be a red flag where you might want to consider another vendor. So why is compliance so important? Diana previously went into some of the potential ramifications under a variety of the privacy laws, and I just wanted to go into some of the risks for not complying with your fiduciary duties. One is a waiver of confidentiality or the attorney-client privilege. Another is you could face a suit for malpractice or breach of fiduciary duty. You could be involved in a fee dispute with your former client. It could lead to consequential damages if hackers get into your client's trust fund account and steal money. According to at least one recent ethics opinions, if the firm didn't take reasonable steps to protect that information, security measures, the lawyer might be responsible for replacing those hacked client trust funds. And finally, there's a risk of state bar discipline. And some of the safety measures I'll go over, but the ethics opinions recommend strong passwords, policies and procedures, and use of encryption and security software. Now, in sum, I just want to go over a basic kind of checklist of what you can do to help in complying with your fiduciary duties. This is important not just to avoid liability, as I mentioned on the previous slide, but also many clients are demanding this now. Especially some of the banks like Bank of America and Merrill Lynch are now requiring firms to fill out long questionnaires about their security practices, and even sending in their own auditors to interview and inspect the practices in place at particular firms. So first, you should really inventory the data that's being maintained by the firm and the devices that are being used by the employees. Is the firm even able to support all of that? It's important to involve IT staff or consultants, but you still have to, as attorneys, manage the security policies and practices. You can't just delegate completely to an IT manager to enter into maybe a cloud vendor contract and exercise no oversight. You have to do some due diligence. And that diligence includes making sure you have training and policies in place, as I mentioned before, BYOD, privacy policies, social media policies, implementing some form of mobile device management as more and more employees are working remotely. Also, if an employee leaves the company, make sure you have departure procedures in place to remove their access and to remotely wipe any mobile devices. You should also have a disaster recovery plan in place, requirements for breach notification, and with all these due diligence efforts, it's important to document everything, including the training and your oversight of the vendors. So the bottom line here is just that reasonable due diligence is required to comply with your professional obligations. And I'm going to turn it over to Diana in case she has a few pointers, and also so we can entertain some questions at the end.
Yeah, so we're getting real close here on time, so I'm just going to go through this really quick, and then if people want to stay over to ask more questions, they may. So some more things just to think about would be, again, bring your own device policy, because you can have a really buttoned up privacy policy, but then somebody brings a device from home and it's, they download a bunch of stuff from the office, or they upload things that they have. So, and it all goes to naught. So really important to think about external devices and how they interact with what's in the office. A privacy policy, as I said before, we talked about a secured email interface. I can give you some names of some that clients have tried. An encrypted hard drive is something to think about. That's probably safer, I think, at the end of the day than using a box. Although something like Box or Dropbox, although they're probably more prone to breach than you are probably also going to indemnify you if something like that happens. And then, of course, thinking about strong passwords, maybe using a password management software system. Those are really easy, and they'll generate passwords for you. But really using a password that's meaningful, having different passwords for different kinds of things. And here are some resources that Sarah put together that we thought would be helpful for you. And lastly, here is our contact information again. And I'm going to just, if you want to take a look or you want to contact us about anything, I want to just go over the housekeeping items again, which is that after this is over, you will get an email from Lauren, my administrative assistant, who will ask you to fill out an evaluation. It's a really quick one, and once you do that, then you'll be passed through to a landing page where I'll have SlideShare, so it'll have the slides, and then it'll also have a certificate of attendance if you need it, and it'll have a recording at some point, probably at the end of the day today. It's also, we will need your bar number, so please do email Lauren at dianamaierlaw.com and send her your bar number so we can record that you're claiming credit as well. And if you forget that, you can just email me, or when you pick up your certificate of attendance, hopefully that will jog your memory. Thank you so much for coming, and I am going to go ahead and just take any more questions for anyone who wants to stay over for a few minutes here.
Yes, thank you, everyone.
Okay, well, I'm not getting any more questions, and it is past the hour, so I think we're going to conclude this. And Sarah, thank you so much again for your all the incredible knowledge you have, and for sharing that today. I really appreciate all the work that went into it. And thank you everyone. And thank you so much for everyone for coming. We really appreciate it.